The 14th Amendment was passed in 1868 to protect individual civil and political rights from being infringed on by any state. It was mostly passed to protect citizenship rights of freed slaves and overturn the Dred Scott decision of 1857. The Equal Protection Clause of the 14th Amendment provides equal protection under the law to every citizen in the U.S. and therefore citizens of states. The Due Process Clause keeps state and local governments from depriving any citizen of life, liberty, or property without due process of law. The definition of selective incorporation is applying certain rights in the Bill of Rights to states and not just the federal government. Selective incorporation and the 14th Amendment are related because of the Due Process Clause and the Equal Protection Clause. The Supreme Court has used indecisions to rule that a state law violates equal protection of citizenship or due process of the law and strikes down the law. When the Supreme Court strikes down the law, it rules that a federal right from the Bill of Rights also applies to all states. However, this does not mean that all amendments of the Bill of Rights apply to states. There are cases in which the Supreme Court has ruled against incorporation of a federal right to state laws by saying that a state law does not violate equal protection or due process of the law.
Let's see an example.
Okay.
Okay, so if I'm the United States and she's the Fourth Amendment, in Map v. Ohio, the Supreme Court ruled that the states had to adopt the Fourth Amendment because it it violated due process. So now we're together.
Forever.